Hey guys, attorney Marc Victor here with the Attorneys for Freedom Law Firm. And I get asked this question a lot. Hey Marc, how do you feel about mandatory minimum sentences? So I thought we'd make this short video just to put a few thoughts down to discuss the concept of mandatory minimum sentencing. So first off, what the heck is a mandatory minimum sentence? Well, a mandatory minimum sentence really is a situation where the legislative body, so think in the federal system, Congress, and the state system, the state legislature. Remember, we have two different criminal justice systems in our country, right? There's a federal criminal justice system and there's a state criminal justice system. And the federal system certainly applies and uses mandatory minimum sentencing. Many states also have mandatory minimum sentences. So what is it? It's when the legislative body of either the federal or the state system basically tells the judge, the judicial body, hey, if somebody gets convicted for this particular crime, you have to give them a sentence of at least this much or that much. They basically impose the sentence on the defendant through the judge. So it basically strips a judge of the discretion to decide what the sentence should be. Now, maybe at first blush, this sounds like a great idea, right? Hey, if somebody commits this kind of a crime, they should get this kind of a sentence. So it might sound like, what's the big deal, mandatory minimum sentencing? Because, some crimes are so serious that there should be a certain minimum sentence for that crime. Sounds realistic. However, in practice, there can be real problems with this. And I guess as a starting point here, you might mention or think about the fact that this is the United States, right? We're supposed to be the land of the free, not the land of the incarcerated. So the fact that the United States leads the entire civilized world in how many people we incarcerate. Now, I'm not just talking about here because we've got a lot of people, in prison. That would be raw numbers, but also by percentage of population. Yeah, so even if you just look at how many people do we have in our population and what percentage of those people are actually incarcerated, we lead the entire civilized world. So you should say there's a problem here with how many people we have in prison already, and really mandatory minimum sentencing has a lot to do about this. And I say this as somebody who's been practicing criminal defense now for 27 years in both the state system and in the federal system. So there really are two phases in a criminal case. Think first the guilt phase. The question, is this person actually guilty of the crime? That's the guilt phase. And then, if the answer is yes, they're guilty of the crime, then the question is the punishment phase. What is the punishment going to be? And that's really where the mandatory minimum comes into. If you're guilty of whatever particular crimes have a mandatory minimum sentence, well then in the punishment phase, the sentencing phase, the judge is required to give that sentence. So think about them in both phases. And really there are problems as a result of mandatory minimum sentencing in both of these phases, and they result in over-incarceration. This is a problem in our country. We can't both be the land of the free and the land of the incarcerated at the same time. There's a very serious inconsistency there, at least in my opinion. In order to talk about this, let's consider a case that you might think at first blush would be appropriate for a mandatory minimum. Something like a murder, maybe a first-degree murder or a second-degree murder. Think about an intentional killing of another person. Well, many of these in both the state and federal, they have mandatory minimum sentences. So if you commit a murder, first or second, well then you have to get X number of years, let's just say 25 years or so in prison. You might be thinking to yourself right now, Marc, what's wrong with that? If somebody commits a murder, then they should get 25 years in prison. I don't have any problem with that. Well, let me break it down for you. First off, huge problems in the guilt phase. Why? Well, consider the facts, questions that I get often asked. when I speak of gun issues. People always at various gun shows or people in gun groups will want to ask me questions, and they all sort of fit into a reasonably similar box. They go like this: hey Mark, what happens if it's 2 o'clock in the morning and I'm home sleeping? Maybe I've had some alcohol, but I'm sleeping in my bed. I had the alcohol at home, maybe with dinner or something, and I hear a thud. And so I grab my gun and I get up, and hey, there's some guy in the living room. Maybe he looks like he's threatening me, so I grab my gun and I go to shoot him, and just as he turns, boom, I shoot him and he gets hit in the shoulder, and maybe he dies as a result of that. And the person gets charged with, let's just say, first or second degree murder, the charge of being intentionally killing another person without legal justification. Now, this might be a close call under the set of facts that I just brought out, because it could be a self-defense case, but if the person is there to steal the TV set, well, then you don't generally get to use deadly physical force in defense of property. I can certainly tell you not in the federal system, and not in the state of Arizona, and not in the state of Hawaii where we practice. We do cases in other states as well, but I've yet to see a state, and there may be one or two, that allows a person to threaten or use deadly physical force to protect property. In addition to that, you might say, okay, maybe the guy wasn't there to steal the TV. Maybe he really was a threat. But if he's turning to leave at the time, well, then the threat is no longer imminent. Remember, for self-defense, you always have to have an imminent threat in order to use deadly physical force. And if this person was turning, at least that might be the argument, to leave, now you don't have self-defense. You've got street justice, and that can be a problem. Of course, if you shoot the person in the back, with a few exceptions that you could imagine under the facts, that almost always is not going to be a justified shooting. That's why I give you the hypothetical, the shooting in sort of the shoulder. So maybe it's a close call. And so in that kind of a case, the reason this is a problem in the guilt phase of the case is because you made a close call here. Maybe the defendant says, hey, look, I was truly afraid for my life, and I really want to take this case to trial. Well, the mandatory minimum makes it very hard for that person to, as you might imagine, roll the dice and go to trial. Why? Because the prosecutor knows this. Mandatory minimums aren't a secret to the prosecutor either. And so the prosecutor's attitude is going to be, look, this defendant isn't going to roll the dice at trial, especially in a close case, and risk 25 years in prison, so they may offer a plea. Imagine if you were in this situation and you felt like truly you were really innocent, not just not guilty, but actually innocent of this charge. Maybe you really did have in your head that there was an imminent threat of serious physical injury or death. You can change the facts a little bit. Imagine the person has a gun at the time and maybe actually pointed it at you and then put it down and turned. So you can tweak the facts in any direction here and sort of tinker with the idea of self-defense. But imagine a close call like that, and then the prosecutor offers a plea that says, look, hey, I realize there might be an argument. How about this? You plead guilty to maybe a lesser charge like a manslaughter and do a couple of years in prison or maybe even probation. You're out the door and that's the end and you don't have to go to trial. Well, this presents a very difficult question for a defendant who actually wants to go to trial. Who's going to risk 25 years in prison if you got a great deal for probation or maybe a couple of years in prison? I can tell you, as a practicing criminal defense lawyer for the last 27 years, most people do not want to take that risk. In fact, the vast majority of people don't want to take that risk, even people who have good arguments at trial. So the net effect of this is it really deprives people, defendants who are charged with crimes, of their right to go to a jury trial because the risk is so high. So this is a huge problem in mandatory minimum cases because a lot of cases, and I've personally been involved in these types of situations where I've said to the client, look, I think you've got a good argument here. I think you're probably innocent. I think there's a really good chance you're going to be found not guilty at trial. But if you're found guilty, you're going to spend, in essence, the rest of your life in prison. And often clients will say, hey, Mark, that sounds like a big risk. What do you think the chances are that I'm going to win at trial? Well, officially, I'm never going to tell you better than 50%. That's the best odds that an experienced criminal defense lawyer is going to give you at trial, because nobody ever knows who's going to be on the jury or what a jury will do. But imagine even if I told you 90% chance that you were going to win at trial. Are you still going to take the risk, even 90%? And no responsible criminal defense lawyer is going to tell you you have a 90% chance of winning at trial. But imagine if you actually did. Say the defense attorney told you you have a 90% chance of winning at trial, and he was actually right. Let's just say somehow we could calculate those odds. Are you really going to take a 10% chance that you're going to spend the rest of your life in prison? And the answer is almost certainly no. You're going to take the 100% guarantee of probation, or maybe 2 years or something like that. That's what the plea bargain is. This is the reason, of course, in my opinion, that we have about a 97% rate of people taking plea bargains in the system, and only about a 3% rate of people going to trial. They just don't want to take the huge risk of going to trial, rolling the dice. So there it is. In the guilt phase, another way to say it is mandatory minimum sentencing, the mere existence of mandatory minimum sentencing, it actually results in depriving people of their right to a jury trial. And we don't really want to do that in a free society. There are many cases that are close calls. Well, I'll be talking to a prosecutor and I'll say, look, this one's a close call. I don't know if a jury would see the person is justified or not justified, or said a different way to put it in the language of self-defense, if the person acted reasonably or unreasonably under the totality of the circumstances. So that by itself, in my opinion, is a sufficient reason to entirely do away with mandatory minimum sentencings. And of course, the other side of this is the sentencing phase, right? The punishment phase, if you will. Huge problem here too, because not all murders are the same, right? There's a difference between somebody who went out and maybe thought about it, sort of premeditated, your classic first degree, or actually intended to kill somebody, maybe without premeditation, more of a second degree type of a charge, did it with an evil mind, and somebody who made a bad decision in a split second, late at night, maybe after drinking. You might imagine there could be a case where somebody might risk it, even on the facts that I laid out earlier, might risk it to go to trial. And in the sentencing phase, if they're actually found guilty, the judge probably would give probation, right? If you make that person 80 years old and no priors and lots of mitigating factors, lots of good things about the person, they've had lots of charitable work and done great things in their lives, and never anything wrong with them. Imagine the judges got to send them to prison for 25 years. Well, in a case like that, if it's just a simple miscalculation and it's not likely to be repeated, right? The purposes of sentencing are to punish another person, to deter another person, and to rehabilitate another person. You can imagine a situation where even a serious crime, person doesn't actually need to be rehabilitated. This was a sort of a one-off type of a situation, a unique set of facts, and they don't need to be deterred either, because they're not going to do this again. The question is, what's the proper punishment? It may be that probation is the appropriate sentence, even on a murder. But the judge is deprived of that option. So it results in unjust sentences as well for people who do roll the dice and go to trial. So it's really a bad idea to try to, in a sort of wholesale way, put everybody who's guilty of a specific crime in the same punishment box. People will say to me often, hey, Mark, have you ever done a case like this? And sometimes in a flippant way, I'll say back to them, never. This is the first case I've ever had like this. And the reason for that is the facts of every case are unique. And so while a legislator might say, if you commit this kind of a crime, you should get this kind of a sentence, a judge who sits there and listens to all the facts of the case, watched every witness, looked at all the physical evidence, went through the exhibits, understands all the aggravating and mitigating circumstances that are involved in the unique circumstances and facts of that particular case, the judge is really in the best position to fashion the sentence under the circumstance. So when the legislature takes this away from the judge, the chances are very, very good we're going to get an unjust sentence. And that's what happens in these cases. That's why we have people right now in prison serving ridiculously long sentences for sometimes foolish little crimes, maybe because they had priors, and we have mandatory minimums that occur because people just simply had priors, and maybe the case at issue in question isn't that big of a deal, but because of the priors, they got a huge sentence. Or there could be some other enhancement or something else about the unique circumstances of the case that require a mandatory minimum that really isn't appropriate. Sometimes somebody might just be just a tad into one of these categories, and now that triggers a mandatory minimum sentence that results in a hugely unjust sentence. So just to wrap it up, mandatory minimum sentences, what they do is they take discretion away from the judge to fashion a sentence that's appropriate under the circumstances. And because the circumstances are unique to every single case, they result in unjust sentences, and they also result in people failing to exercise their right to a jury trial, their constitutional right to a jury trial, simply because they are so afraid of rolling the dice under the circumstances. The way to fix this is to repeal mandatory minimum sentences. There's another way to do it. Here in Arizona, we have an initiative process. It would be great to have an initiative on the ballot that was short and sweet, simply said something along the lines of, notwithstanding any other law to the contrary, a sentencing judge always has the discretion to impose probation in any particular case for any particular charge. This would dramatically change things in the justice system. Doesn't mean that people are going to get off easy. It just probably means that the pleas that would be offered in a close call case would more reflect the fact that the case is a really close call. Because if not, then people would exercise their right to go to trial, and if they got convicted, they could still pitch to the judge at sentencing, hey, this person should get probation notwithstanding a serious conviction. I don't think we're going to have a problem in our justice system if we allow more discretion for the judge to determine the sentence rather than the combination of the legislator and the prosecutor. Because remember, the prosecutors know about this, and they can intentionally charge whatever crimes they want to charge within reason, and so they oftentimes will select charges and enhancements that are attached to mandatory minimum sentences with the understanding that this is going to provoke a plea and the person is out the door in a quick plea, and instead we didn't get a jury trial, and this results in lots of injustice in our system. So in any event, those are my thoughts on mandatory minimum sentencing. Often I like to hear from you. I like to get your take on it, whether you think I got it all wrong or you think I got it right. Happy to hear what you have to say about it. I'm very, very easy to get a hold of. You can always contact me through my law firm website, real easy, attorneysforfreedom.com. You can get a hold of me directly. You can just email me, Marc, M-A-R-C, at attorneysforfreedom.com. We are a very hardcore pro-freedom group of lawyers. I call them the wild pack of wolves. We're all freedom activists. We feel that way on every possible issue, and we're always happy to defend people in criminal cases. We also do civil rights cases as well. If you feel like you've been wronged by the government, we'll review your case. We're not going to take every case, so don't be upset if we don't take your case. But if you have a worthy case that should be brought against the government, that's what we like to do. We do civil litigation as well and personal injury. So if you ever have any questions, feel free to get a hold of us, generally at the law firm. And if you want to react to this short video on mandatory minimums, feel free to hit me up in person. Again, my name is Marc J. Victor, and this has been my take on mandatory minimum sentencing.